Right. Here we are in the court again. About to go in for sentencing.
I'll be there about 5 minutes ago.
Sorry, Mummy. I just want to be near the front so I can hear it properly. Are you both here?
Yeah.
Right. Are you going to sit there? Or?
And I'm not being funny, but just was really clear we want everybody to be quiet. Is that going to be alright?
Yeah, I understand that, yeah.
I just didn't, I don't want to have to ask you to leave it, so I'd rather...
I understand what was said.
That's
I do.
First of all, I'm going to make sexual harm prevention orders in relation to each defendant until further order. I'm satisfied that it is necessary to make such an order in order to prevent further serious offending by the defendant. By virtue of this order, each of the defendants is prohibited from living or staying or being or remaining in the same household with any child under the age of 16 years, unless with the express approval of social services for the relevant area, from having any unsupervised contact or communication of any kind with any child under the age of 16, other than A, such as is inadvertent and not reasonably avoidable in the course of normal daily life, or with the express approval of social services for the relevant area. From possessing any device capable of storing digital images unless he makes it available on request for inspection by a police officer. From using any device capable of accessing the internet unless firstly it has the capacity to retain and display the history of internet use, and secondly he makes the device available on request for inspection by a police officer, and from working in any capacity, whether for payment or voluntary work, where any child who is or reasonably appears to be under the age of 16 years is present. if a defendant breaches any of the prohibitions on this order, he commits an offence punishable by imprisonment. The defendants can remain seated. The 11 victims in this case were young teenagers. It is clear from the evidence that I heard over many weeks that each of them had suffered difficult upbringings, some from broken homes, some from violent homes, and some from homes where there was little or no parental guidance. No doubt in part as a consequence of that, most were taken into care, and each of them committed criminal offences. As a result, each was sent to St. William's Community Home. You, James Caraher, were a member of the De La Salle Catholic Order. You were not a priest, but you had taken religious vows. You went to St. William's as a teacher, then became deputy head, and finally head of St. William's. You, Anthony McCallum, were a Catholic priest, ordained and subject to the religious vows which you had taken. Over a period of many years, each of you committed offences of indecent assault and buggery on boys in your care. These boys were entitled to look to you to care for them, to educate them, and to guide them, so that when they were released, they would have a better chance of living a decent and honest life. In many ways, you were acting in loco parentis. It is perfectly clear that each of you targeted some of the most vulnerable boys. You groomed them, abused them for your own sexual gratification, threatened them to ensure that they did not complain, and you, Caraher, were physically violent. These victims were particularly vulnerable, not least by reason of the fact that they were the subject of court orders and were not free to leave. They were effectively trapped, and there was no escape from you. It is difficult to imagine a worse case of breach of trust. You held highly respected positions, and you used those positions to commit these offences. Each of you was aware that these boys would be unlikely to complain, and if they did, they would not be believed. At one stage, each of you was warned about your conduct, but no steps or no effective steps were taken against you, and you continued to offend. Indeed, it's clear that you, Caraher, at one stage used your position in the home to protect McCallum when concerns were raised by other members of staff. It is perfectly obvious that each of you has a long-standing and deeply ingrained sexual interest in teenage boys. It is an interest which I have no doubt continues to persist. As I observed each of your victims in the witness box, it is clear that each of them has suffered severe, long-term and continuing psychological harm as a result of what you did. It would not be right to lay all their offending and their problems at your doors, but each of you has contributed significantly to their misery. You bear a very heavy responsibility. It is difficult to comprehend how these boys must have felt at the time. They were confused, frightened, and in turmoil about what was happening to them. They did not complain for many reasons, including confusion, fear, embarrassment, and the likelihood of them being disbelieved when it was their word against a headmaster and a Catholic priest. as a result, they have carried this abuse with them for many years, and as I have said, it has blighted their lives. Indecent assaults involve touching over and underclothing and masturbation. The acts of buggery involve no protection and ejaculation. It was painful, and you persisted despite the tears and persistent, regular, and over a very significant period of time. I observed each of you giving evidence in the witness box. You lied persistently and showed no remorse for what you have done to these victims. In assessing the appropriate length of the inevitable custodial sentence in your cases, I have had regard to the maximum sentence for these offences, the guidance given in approaching sentencing in historic cases, the sentencing guidelines, the aggravating and mitigating factors, and the principle of totality. In your case, Caraher, I have also taken into account the particular circumstances in which you fall to the sentence, and I will deal with that in due course. Turning to each of you individually, James Caraher, you are 75 years old, and you were convicted by the jury of 21 offences of indecent assault and 3 offences of buggery involving 7 complainants over a period of between 13 and 16 years. Looking at the sentencing guidelines for rape, each of the offences of buggery would fall into category 2. When looking at harm, however, the severe psychological harm and the particular vulnerability of each of your victims elevate this case to category 1. Culpability clearly is at level A. That gives a starting point of 15 years and a range of 13 to 19 years for a single offence. There are additional statutory aggravating features of ejaculation, the location of the offence, and the steps taken to prevent victims from reporting. So far as the indecent assault offences are concerned, they fall to be considered within the sexual assault guideline. They are clearly category 1A offences, with a starting point for a single offence of 4 years imprisonment and a range of 3 to 7 years. In assessing the mitigating factors, I've taken into account everything which Mr. Saxby, Queen's Counsel, has submitted on your behalf, particularly the fact that you have not committed any further offences since the 1980s, your age, the fact that you are being sentenced to a 3rd term of imprisonment arising out of the same series of offences, and the fact that you have been on courses designed to reduce your risk of reoffending. If I was sentencing you only for the offences which this jury convicted you of, I would be imposing a total sentence in the region of 20 years imprisonment. Your case is, however, a complex one, because in 2 previous trials you have been sentenced to and served a total of 21 years imprisonment. These offences were all committed at St. William's during the period considered by this jury. In the first trial, you were convicted of 12 offences of indecent assault, 1 of buggery, and 1 of attempted buggery. You were sentenced to a total of 7 years imprisonment. After you had served those sentences, you were convicted in a further trial of 15 offences of indecent assault and 7 of buggery. You were sentenced to a further 14 years imprisonment, which you have served. In imposing that sentence of 14 years, the trial judge adopted the approach of considering the appropriate total sentence for all the conduct covered by the offences for which you have been sentenced in 1993 and the offences of which you were convicted in the second trial. He concluded that the appropriate total sentence was 21 years, from which he deducted the 7 years you had served and imposed sentences of 14 years imprisonment. That approach was approved by the Court of Appeal in your renewed application for leave to appeal against the conviction and sentence, which was heard on the 9th of May of 2006. That is the approach which I adopt. You have previously been sentenced to 21 years imprisonment for a total of 27 offences of indecent assault, 8 of forgery, and 1 of attempted forgery. You have now been convicted of 21 further offences of indecent assault, including 4 multiple occasion counts and 3 offences of forgery. The question I have to ask myself, therefore, is what would be the appropriate total sentence if I were dealing with you for 48 offences of indecent assault, 11 offences of forgery, and 1 of attempted forgery. In my judgment, that would have justified a total sentence of 30 years imprisonment. Accordingly, the sentence on counts 18, 19, and 66 is one of 9 years imprisonment, and for each of the offences of indecent assault, 5 years imprisonment. All those sentences will run concurrently with each other, making a total of 9 years imprisonment. You will be liable to serve up to half that sentence, and when released on licence, if you commit any further offences or your conduct warrants it, you are liable to be recalled to custody. Anthony McCallum, you are 69 years old, and you were convicted by the jury of 10 offences of indecent assault and 1 offence of forgery involving 4 complainants over a period of between 10 and 12 years. As with Cara, the act of forgery involved both and you ejaculated. You told your victim that he was paying for his sins. You made threats to Mr. Riggott that if he complained, he would not be allowed to go home. You told Mr. Commons when you abused him that he would be safe and no one would hurt him whilst he was at St. William's. You told Barry Bartram that what you were doing to him was just normal, that he was your favourite, and you would make sure he got looked after. As a priest, you breached the solemn vows which you have taken. Looking at the sentencing guidelines for rape, I'm just persuaded that this is a Category 2A offence for the reasons discussed during the earlier part of this sentencing hearing. That gives a starting point of 10 years custody with a range of 9 to 13 years. As I have said, in your case, I propose to pass consecutive sentences for the indecent assault, which clearly fall into Category 1A, with a starting point for a single offence of 4 years imprisonment and a range of 3 to 7 years. In assessing the mitigating factors, I've taken into account everything that Mr. Gunning has submitted on your behalf, particularly your health. There have been no further allegations against you since 1993, and to some extent your age. You served a 2-year sentence in 1993 relating to indecent videos, taking indecent images of children, and 2 offences of non-contact indecent assault on boys under 14. Those offences were not committed against boys from St. William's, but in different circumstances and relating to children of your parishioners. Had I been dealing with you for those matters now, inevitably there would have been consecutive sentences, and therefore, subject to the principle of totality which I have fully in mind, your position is different from character. The least sentence on count 44 is one of 10 years imprisonment. For each of the offences of indecent assault, there will be sentences of 5 years imprisonment. Those sentences for indecent assault will run concurrently with each other, but consecutively to the sentence on count 44, making a total of 15 years imprisonment, of which you will be liable to serve up to half. You will then be released on licence, and if you reoffend or your conduct warrants it, you will be liable to be recalled. Anything else? You may go down. it will have been obvious to the jury and to anyone observing this case, and to me, that this was a particularly difficult investigation. Made more complex by the nature of the offender, the nature of the victim, and the difficult lives which they have had to endure since. In my judgment, the investigation in this particular case has been impeccable, and officers have gone well beyond what might normally be expected in investigations. And on my part, I commend Detective Chief Superintendent Wilson, Detective Sergeant Joanne Taylor, Detective Sergeant Christopher Woodhead, David Holmes, Jeanette Robinson, John Wilson. Those are the particular officers I highlight, but there are obviously many others who I don't know. And I'm very grateful to Leeds to Wright and to all the advocates in the case for the, if I may say, the appropriate and measured way in which this particular difficult case has been conducted. And I'm also very grateful to all the assistance which you gave me in dealing with
What was that?